Lord, two short housekeeping matters. The first is that the judges have now written in to say that they don't object to publication of their note.
Yes, good.
And secondly, Mr. Tyzak has indicated that, again, there's no objection to his skeleton argument being published in full.
Also good.
My Lord, having reflected overnight, we, on behalf of Mr. Sharif, do make the application to file and to adduce the second annex, which is the annex dealing with the social media posts. We produced overnight a draft witness statement by Ms. Wiggett, draft of which we circulated to the parties and also sent through to the Court of Appeal. I have the signed copies, which are directly below and can be passed up.
Okay, we don't need signed copies. We've got a copy.
Fantastic.
And that's very helpful.
Our position is that your lordships and my lady have a whole range of options, and depending on which route the Court of Appeal decides to take, this is clearly relevant evidence because it sets out the response of the public, albeit limited to the 19th of December. It gives this court certainly a context and a temperature at that time.
So this material was all available at the time of the decision?
It was, but my Lord...
Not fresh in that sense?
It isn't fresh in that sense. The difficulty, my Lord, is that we don't know which of these posts his Lordship, Williams J, had read or indeed in any way taken into consideration. His general summary assessment, we say, was on likelihood and a taking of temperature because this was a high-profile case with likely significant criticism.
I hadn't detected anything in the judgment that indicated that he looked at
Well, precisely.
There's not really a question of which.
We
And
just
the reason he
don't-
didn't look at them is A, he didn't look at them, and B, he wasn't asked to
Correct.
by you or anyone else.
Correct.
Yeah.
My Lord, sorry. That's true. The posts obviously post-date the decision of the court, but not the judgment.
Well, some of them are 5 days old at the time of they were looked at. But anyway,
My Lord, what the court doesn't have is the current temperature, but more importantly, we don't know what the reaction is going to be if the court allows publication of the judges' names and if that triggers the potential publication of not only their names but photographs of each of them and the response to this decision by the public. And it's difficult to gauge whether or not we're going to have similar threats because we clearly had a range of threats. There was certainly hanging, there was shooting, and that there was placing the judges through the grinder and a photograph, which is actually a moving clip of a working meat grinder. One of the concerns on behalf of Mr. Sharif that we voice is that the judge's note makes it quite clear that they have a genuine fear, a genuine concern, not only for their own safety and possible risks to them, but their families. And we say that is a link, that is a nexus. And the difficulty, my lords and my ladies, that as you rightly said yesterday, we don't have the particular characteristics of the individual judges, what they have been through, what their current situation is, what their family circumstances are, and what psychological difficulties they may have as a result of either this or other matters, and whether this will in some way aggravate and make matters considerably worse for their own psychological makeup. We just don't have that information. My Lord, you asked yesterday of Mr. Barnes and also Mr. Wolanski, King's Counsel, what if a judge was to make that decision today? And what if there was some indication from the press or otherwise of a potential threat or threats? The difficulty that we have is that we don't know for sure what the public reaction is going to be to the naming of these judges and the publication of their photographs, and linking them to, in particular, one judge, to the placement of Sara Sharif with my client. And the real issue is the unknown. How does the court assess that risk? And on a worst case scenario, without a police risk assessment, without HMCTS being able to provide you with an update in terms of any approaches that have been made to that court and those judges, it's difficult to be able to have a complete picture. But this is the best that we can offer. We felt it was important for the court to have sight of the type of posts. And as we say, this is not an exhaustive list. It is what we managed to extract on the 19th of December. We may have a whole range of new posts, and I would submit that that is likely.
Okay.
Well, could I finally just deal with the issue of the material procedural irregularities, just very briefly? We do set out in our skeleton opposition in this, but could I just highlight 3 points? The first is that we say all parties signed up to what was essentially a hearing with a summary set of decisions, at the end of which that was going to be announced with a full judgment to follow in January. That was always made known to the advocates and to the parties who signed up to it. Secondly, it's right to say that before Mr. Justice Williams had announced the final decision in a list of decisions, which was, should the family members be able to approach the press, Mr. Barnes invited the court to allow him to produce a skeleton argument or written submissions overnight. That was acceded to, and then Williams J. proceeded to deal with the final decision, which was about the family members approaching the press. In fact, Mr. Barnes did produce a skeleton or written submissions, which I know the court has seen, and I won't necessarily take you to it. But you can see from that that he argues essentially fully his position and the press's position on the disclosure of the judge's name, judges as in plural. And so Williams J. had the opportunity to review and reconsider his decision, which we say he was entitled to, which is what he did. He did decide to maintain the prohibition on the publication of the judges. He did consider the skeleton and review the decision in light of that. No other parties certainly produced any detailed submissions like Mr. Barnes did, but there was a document on behalf of the journalists, Ms. Summers and Ms. Tickle. The final point really about this is that if you do decide to refuse the appeal there is a process here, which is that Williams-Jay's made it clear that he would review this case in March, and he will obviously review any applications made to him by the judges and indeed any party, and review any evidence that might be filed and served in order to assist in that review process. So that is already in place. And I would submit that depending on what the decision of this court is, that judges do, in fact, review their decisions, and this judge is more than capable of being able to review this decision in light of any directions made by the Court of Appeal. So really, those are the short points that I want to make today. I'm grateful to you.
Thank you very much. Thank you. Ms. Burton, you don't want to make any submissions?
My Lord, no. I think only if I was called upon by the court to do so. I think you have Ms. Batool's position in our position statement at page 181. I should say, to be fair, that that has been her position from the beginning, because you'll recall that it was reported she was opposing the appeal, but that has never been the case. But unless I can assist you any further, I will sit down, my Lord.
Thank you very much. Yes, Mr. Verdon.
My lord, my lady, thank you. As you know, together with Miss Folkes, we represent the 6 children through their children's guardian, and you have our skeleton argument at page 184 of the main bundle. And it's important to note at the outset, as we do in the skeleton, and I make this point for the wider audience because I know this court is well aware of it, that this particular children's guardian was appointed in the High Court proceedings in September 2023 and therefore had no involvement in the historic proceedings and was never children's guardian for Sara Sharif. Her role, as this court knows, was and is only to represent the voices and the welfare interests of the subject children. We made that point in the skeleton. And you'll appreciate, therefore, that our submissions are limited, and even more so now that this court yesterday heard submissions from all the other parties on the law. If you'd allow me to make some general observations firstly, they may be trite.
Can I just ask you, Mr. Verdon, to confirm in open court what is said in paragraph 8 of your skeleton argument, to the effect that you, having considered the matter, and the guardian having considered the matter, that so far as you are concerned, the publication of the judges' names is not a primary welfare issue for these children, i.e., you say, this decision does not have a direct welfare impact, and accordingly, she does not seek to advance any positive case on the appeal. Now, is that the position?
That is categorically the position, this experienced guardian having considered carefully the potential welfare impact of this narrow but hugely important issue. And thank you, my lord, for drawing my attention to that point. And it is in contrast to her position in the lower court, where issues of publication arose and where there was an impact on the welfare of the children and their Article 8 rights. And in those circumstances, as the records show, she took a particular positive stance. In contrast, for this appeal, she does not. And my lord, it's important, again, for the wider audience to clarify this point and repeat it, because yesterday afternoon, I'm reliably informed, one of the mainstream media reported that the Guardian opposed the appeal. She doesn't.
Thank you.
Some general points which I appreciate in the context of this case are somewhat trite, but they do bear, I would submit, repeating. I agree with all the submissions made by my learned friend Miss Fottrell in relation to the complexity of the case, and agree with her, and it's obvious, that the learned judge, Mr. Justice Williams, had extensive knowledge of it and devoted significant resources to it prior to the making of this controversial decision. and you will know, and we've seen the chronology that's been prepared by the local authority, which, subject to one addition, we completely agree is an accurate record of the procedure. It should include also the order of the 13th of December at page 57 of the main bundle, which is where the learned judge deals with more issues arising from, in particular, for example, the permission to appeal. You have that in your bundle. That can be added to the document. So a vast majority of hearings have focused on the media applications. A considerable amount of court time has been spent and resources spent on them. And we say that is one of the relevant background factors. May I signpost the shape of our submissions to assist this court, and I'll be brief in relation to each of them. I've already clarified the position of the children's guardian in the lower court. In somewhat more detail, you'll know, and it's not disputed, that it was the children's guardian's team that highlighted the BBC schedule as it's described. It's a 56-page document, and it was the children's guardian's team that highlighted the names of professionals in that schedule and suggested that those persons, if they were to be named, should have some sort of notice of that fact. And we refer to that, my lord, in our original skeleton, dated the 6th of December at paragraph 23 of it, and that's supplementary bundle, document 17, page 126 at 133, but I don't need to take the court to it. For the avoidance of doubt, the judges' names were not highlighted by the children's guardian's legal team, and the children's guardian was not at the time suggesting that the judges needed to be notified. Pausing there, with hindsight, given what has happened in this case, perhaps that should have been done if that was going to be a controversial issue, which was not anticipated at the time. At the hearing on the 9th of December, you've already been told, and I can confirm, that Ms. Folkes, on behalf of the children, did not make any oral submissions on the issue of publishing the names of the judges and did not make any written ones. We say that at paragraph 19, and obviously nor did any other party. And then following the court's request, Ms. Folkes emailed the court on the 11th of December. We refer to that email. We quote it at paragraph 20 of our main skeleton, and you'll see from that email that Ms. Folkes, again, it goes back to the point that my lord, the Master of the Rolls, made a moment ago, made clear that she was not making any submissions on the issue of naming judges. I turn to the children's guardian's position on this appeal, and again, repeat the point already made that she is neutral, but again, make some general observations to assist this court, which may be trite, but they are, we say, significant. The situation, as my lord, the Master of the Rolls, indicated yesterday on a number of occasions, the situation now is clearly more complicated than it was before the learned judge made his decision, given the spotlight shone on this case by the decision and the appeal. And my learned friend for the father has already referred you to the new information that this court now has, albeit through a circuitous route, which we know the learned judge did not have and did not refer to, certainly did not refer to. And the court has the note, and the court, we know, has read that note and sees what the judges say about their serious concerns about the risks to them. And it's implied in paragraph 12 of that note that they perceive the situation now to be graver than it was previously. And that is something which this court will no doubt take into account. And The references in that note to their view that there should be a full and proper risk assessment are set out in paragraph 15, and in paragraph 15 there's a reference to the MOJ and HMCTS's view of the risk and the vulnerabilities, and the reference to a pending police risk assessment. In relation, turning from generalities to particular grounds of appeal, I'll only say the following in short form, and I repeat, I do not put, on behalf of the children, a positive case. As for process, we made the point in our written document that in relation to the judge's failure to give reasons, we fully accept that the situation was non-ideal, in the sense that this hearing was shoehorned into a busy list, and you've heard probably enough about that already. But out of fairness, we also make the point that the half-day estimate was agreed without knowledge that this novel and exceptional suggestion of not naming the judges was on the table.
Well, it doesn't matter, because the judges weren't mentioned in the
They weren't.
half-day
They weren't.
hearing until the judge announced what he was doing.
Well, we say, with respect, my lord, that that is exactly the more concerning procedural step that was taken. Not so much the failure to give reasons, but the failure to give the parties an opportunity to make submissions on the judge's, perhaps, preliminary view that in this particular case he was considering not naming judges. And with respect to the learned judge, who clearly has spent a great deal of time on this case, had he done that, given the array of talent that was before the lower court, he would have heard a range of submissions on the legal principles and the parameters. And we may not, therefore, have been in the situation that we are in now. And on behalf of the Children's Guardian, we acknowledge that, and having heard all the submissions yesterday and the preliminary indications of the court, we acknowledge that that is a serious procedural irregularity. In relation to ground 2B, my lord, which I'll term bias to the media, and the severe criticisms or serious criticisms made by the appellants of the judge, all we suggest, and it's only a suggestion, is that that criticism needs to be seen in the context of the judge's fundamental decisions in relation to disclosure, rather than his decision on the narrow but important issue of not naming judges. And I say that.
How can that be? The judge's judgment is only concerned with the naming of judges. It is not concerned with any other aspect of the order he made, is it?
The appeal only relates to that narrow point, my
No,
lord.
not the appeal. The judge's 66-page judgment is only concerned with the question of whether or not the judges should be named.
My lord,
Nothing else at all.
my lord, yes, but clearly it's a wide-ranging judgment which deals with a whole range of background issues. But of course I accept my lord's point.
Well, it's only written about one issue. It may cover a lot of other matters, but they are only covered insofar as, in his judgment, they related to that one issue.
My lord, I have to accept that.
Yes, and therefore, to say that it has to be, ground 2B has to be seen in the context of the case as a whole, I mean, is not a particularly attractive submission. I mean, it may be sort of true in one sense. Of course, you need to look at everything in context, but actually the ground is on the basis that he should not have referred to those matters in relation to the question of whether the judges should be named.
My lord, the point we made in writing, and I'll repeat it once orally, but I fully take the indication from you that it's not the best point. The point we wanted to make was that in the wider context, it is remarkable that this particular judge, A, devoted significant resources to the media applications, but B, ordered the widest ranging disclosure, a point which has been acknowledged by the media in this particular case. Hundreds and hundreds of pages. I won't go as far as to say unprecedented, but unusual. A huge amount of documentation. I think in the December hearing, an additional 61 documents were disclosed. So when one is considering a serious ground, judicial bias against the media, we would submit, perhaps this court wants to look at the wider context to see how he behaved generally towards the media before looking at the particular complaint about his conduct on this issue. But I won't take further time in relation to that, my lord. May I turn then to judicial anonymity? And you have what we say in writing at paragraphs 27 to 28. And we have nothing substantive to add to the submissions on law made by others, in particular, Mr. Tyzak, who, of course, has been invited to assist the court. And I've had the benefit of a conversation with him about what he is going to say to you about psychological and physical integrity, and do not disagree with how he puts it, nor, for that matter, how the local authority put it on the Article 8 point. And, of course, we have considered the note put forward. As for jurisdiction, a question that my lord, the Master of the Rolls, posed on a number of occasions yesterday, the answer to that question is in some ways a difficult one, because my lord asked what is the threshold for considering such anonymization? And I know what's going to be said by Mr. Tyzak, and all I would add is this, that I'm conscious that in adding it, there is the potential for setting hares running. But what I would suggest perhaps would be a threshold would be, firstly, exceptional circumstances. Secondly, again, to use some of the words used yesterday, a significant, positive, real, and concrete threat. And thirdly, that the evidence would have to be compelling. And perhaps those three limbs would properly recognize how high the threshold is for anonymization of judges' words. As for procedure, I've already touched on the procedural difficulty in this case, which is one of the reasons why we are here, and would simply suggest, and I appreciate that there are going to be problems with any guidance given by this court for such an exceptional situation, and given that every case is fact-specific. But if a judge is considering anonymization of a judge's name, there must at the very least be forewarning of that, so that not only the parties, but the judge concerned, if it's not the judge hearing the case, which is our situation here, have the opportunity to respond. I'm not sure, on behalf of the children, whether I can go further than that, because she, having been told of the proceedings yesterday and the points raised, shares a concern of the court that setting up a new process does risk in itself causing delay to procedure and taking up more resources, and I turn now to a welfare point, magnifying the focus on the family and the children, which is something she has hoped to avoid. And it's the only welfare point we make in our skeleton, that for two of the children concerned, this court knows the ones I'm referring to, the continuation of the media interest in the case is having a negative impact because they're aware of it. So I'm sorry to say that I'm not sure whether I can make any suggestions which are remotely helpful in relation to guidance that this court may wish to give for such a rare situation, and we've all acknowledged it's unprecedented. As for outcome, this court knows that the three judges, if the appeal is allowed, would like notice of it. And this court may, or may not, I don't put a positive case, may consider remitting the case to a High Court judge for consideration of the new material if this court takes the view, which one would understand, that it's not in a position to carry out any type of balancing exercise based on the new material it has, which it is acknowledged is incomplete. My lord, may I turn my back for just one moment? Unless I can assist further.
Thank you very much, Mr.
Thank you.
Burden. Thank you. Yes, Mr. Tyzack.
My lords, my lady, what I intended to do, in case it assists, is to deal with the 2 points that appear to have arisen of significance, namely jurisdiction and threshold for the engagement of Article 8. On the first point, in relation to jurisdiction, I intended to deal with this principally by reference to my note where I set this out. Can I refer your lordships and my lady to that? But just checking, first of all, that we all have the same version, which is dated 13th of January. I say that because a slightly premature draft version was lodged. But if it's dated the 13th of January, it is the correct version.
Yep, we got that.
I'm grateful. And I set out in that, at paragraph 6, the extension, or the basis on which there is or can be an extension or relaxation to the automatic restraints in Section 12 of the 1960 Act or Section 97 of the Children Act, and the common law development insofar as it relates to others involved in the case, i.e. guardians, social workers, treating clinicians, etc. And the 2 examples, and there are, of course, other cases where the issue is addressed. The 2 examples I offer are at paragraph 7 and 9, the first being the Abbasi case in relation to treating clinicians and a relaxation of a reporting restriction order, and at paragraph 9, X and Y, as an example of the restraints jurisdiction, a specific application for an injunction for the benefit of a children's guardian. And, of course, the question may arise as to, bearing in mind the ambition of reporting restrictions orders, generally speaking, being to protect the anonymity of the children who are subject of the proceedings, potentially the parents as well and family members, but not generally others involved in the case, there has nonetheless been a development along those lines. And that
Sorry,
is
development along what lines?
along the lines of others involved in the case.
Yes, beyond the children. But I mean, this is not a case about others beyond the children. This is a case about judges
Yes.
who are in a different position, are they not?
They are in a different position in that they are, as has been said, at the apex of the decision-making process.
They are the...
At the apex of the decision-making process.
Yes, well, yes, okay. But I didn't find your paragraph 6 particularly insightful, shall we say, because you simply say it's possible such an order may be made. Well, yes, I mean, of course, is the answer to that, and we've had all sorts of examples yesterday, but what we are concerned with is when should, as a matter of jurisdiction, such an order be made.
Yes.
And, you know, I think the clouds are clearing, Mr. Tyzack, from what we saw before the case began. We now know there are no child protection issues as far as naming the judge is concerned from the guardian. And the guardian is the person to whom we would look. Nobody else, including the local authority, has suggested there are child protection issues caused by naming the judges. So that rather rules out the parens patriae jurisdiction of the court to be used as a foundation for an injunction refusing to name the judges. The judges didn't make any application not to be named, so there's no cause of action alleged by anybody So the only, and this is where help is required from you, really. It seems to me at the moment, there's no suggestion of contempt of court. So the only jurisdictional basis for what the judge did seems to me to be Section 6 of the Human Rights Act.
Yes.
Now, the question I ask of you is that right?
My lord, that may be right. I wouldn't disagree with that proposition. The submission I was going to make was that it may also arise in the context of a relaxation application, a relaxation of a reporting restriction order, where the court is considering other professionals involved in the case, generally, of course, clinicians and guardians and so forth. But if the judge's Article 8 rights are, as a matter of principle, engaged in that situation, then, and on such an application being made, as it was here before Mr. Justice Williams in December, then the court couldn't exclude from that analysis the judge. Now, that's not to say that a specific application couldn't be made by a judge, or a judge's Article 8 rights couldn't be considered, as my lord identifies, in the context of a Section 6
I'm
application.
sorry to hold your feet to the fire here, Mr. Tyson.
No, that's
but
quite all right.
The judge's Article 8 rights cannot be considered by the court without some jurisdictional foundation. And the only jurisdictional foundation is the obligation of the court to consider convention rights under Section 6.
Yes.
Now, therefore, in the absence of anybody raising the issue, any application being made, and anything else happening, what I'm asking you is there any other jurisdictional foundation on which the judge could have been acting? Now, if the answer is no, then we can move to the consideration of whether the judge was right to think that under Section 6 he should have done what he did. And
Yes.
then we get to threshold of Article 8 and so on.
Yes.
But if the answer is yes, there are other jurisdictional foundations, then it's a different question. And the reason I was so careful to ask Mr. Verdun what he thought about the welfare of the children is that it seems to me, at least, that in wardship proceedings, the parens patriae jurisdiction of the court could go as far, potentially, theoretically, not in practice, but in theory, as allowing such an order to be made. But that's not this case. So that's why I need help as to whether I'm right to say it is only possibly Section 6.
Well, my lord, is there an answer potentially in paragraph 66 of Abbasi where...
Paragraph 66 of Abbasi.
And I suspect my lord's answer to that will be no, because that makes it clear that it was in the parens patriae jurisdiction in that circumstance. And so where that's engaged, I can see that the analysis would arise, potentially in relation to a judge as well. But my lord is saying here that that issue had come to an end.
Well,
And so I can see the argument.
to an end. It's that it now appears that no party suggests that the parens patriae jurisdiction should lead to this conclusion. I mean, I may be wrong about that, because it may be the father is suggesting that. But the question is what else? Well, the other else might be Section 37, which allows the court to grant an injunction in any case about anything against anyone.
Yes.
As we know from the Wolverhampton case. But in real terms, it seems to me at the moment anyway, that what we're really talking about is Section 6. But that's why I'm asking.
I wonder if, can I, before you get to Section 6, and obviously deal in detail with my Lord the Master of the Rolls' question about that.
Yes.
Before we get to Section 6, just thinking procedurally in a family court on a wet Wednesday, So we've got section 12, we've got section 97, which may not have elapsed. And someone is saying they want a reporting restrictions order in order to vary, extend, or generally interfere with the statutory restrictions found in section 12.
Yes.
Is the route then, rarely mentioned, but actually there, PD 12I, that you're asking for a reporting restrictions order that will effectively vary, consolidate, water down, whatever, section 12.1. And that's the route. Is that right or is that not right?
One answer.
Otherwise, what's PD 12I doing there? I mean, what's the President's guidance about reporting restrictions and all the rest of it there for if it just plays no part in any of this analysis?
One answer might be that it's playing a part for the benefit of the child, and it is an inherent jurisdiction order for the benefit of the child, applying the principle set out in PD 12I. But the difficulty in transposing that across for a judge when PD 12I clearly
I'm just
isn't-
talking about,
Sorry.
I should have made myself clear. I'm not particularly talking just about the judge here. I'm
Right.
talking about the point about PD 12I is it specifically refers to applications where you're considering convention rights. So
Where
when
you're considering, sorry, Milady.
convention rights.
Yes, yes.
So in other words, we're getting, what I'm struggling to slot into the analysis is where, from a procedural point of view, with the family proceedings rules, it specifically say, look at convention rights when you're looking to move away from section 12.
Yes.
Now, isn't that something that is there before you get to section 6?
In that it's engaging the convention rights, and the family court is clearly being invited to engage the convention rights. Yes, I would agree with that.
So you might say social workers, guardians, their convention rights are engaged immediately because they directly affect the welfare of the children
Yes.
when considering under PD 12I.
Yes.
But, and I realise this is one of the big questions in this case, is maybe said that the judges are not, because the naming of the judges doesn't go to the welfare of the children.
Yes.
That's then, how does that then fit with moving on to section 6?
My problem that I would have with that is that we may be confusing procedure with substantive law.
Yep.
And my questions are all devoted to the question of substantive law, not how the question of substantive law comes before the court procedurally. And I don't think the President's guidance, or indeed the practice direction, can change the substantive law.
Of course not.
So I completely agree, actually, that the process by which the question of extending Section 12 is considered is through PD 12I, and that gives you help as to the balance that you may have to perform, but you only have to perform that balance if there is a jurisdictional foundation to do it, i.e. either the parens patriae jurisdiction of the court, Section 37, or Section 6. So the two must not be confused, because you wouldn't get to do the balancing exercise. I mean, these are all questions, not pronouncements. You wouldn't get to do the balancing exercise until you had a jurisdictional foundation to do it, which is Section 6. I mean, that's the way I see it at the moment. But
My Lord,
I stand to be corrected, Mr. Tazak, which is
My
why
Lord, I wouldn't disagree with that. I would agree that PD 12I of itself cannot confer a jurisdiction on the court to make an order.
no.
So the convention rights as engaged must come from somewhere else. And if it can't be the parens patriae jurisdiction, which one can understand the reasons as to why that can't be right, then
It could be, but it just doesn't seem to be here.
It could be if they're engaged, perhaps it might be fair to describe obliquely in the context of considering other convention rights of other people involved in the proceedings, if it's that case. But if it's not that case, and it is freestanding, then your lordship may be right that it's Section 6. But it may result in the same thing.
Sorry, I didn't mean to interrupt you.
It's all right.
You complete what you were going to say.
I was just going to say it may result in the same thing, in the same analysis, ultimately, as to whether and to the extent to which the Article 8 rights are engaged and infringed.
What I was about to say was that, at the risk of complicating things, I noticed that no one's been talking about the common law in this context. And there is quite a lot of jurisprudence about the circumstances in which people, putting it generally, can be anonymised under the common law exceptions to the open justice principle, most notably Officer L, which tells us what the common law threshold is for anonymising a witness for fear that they will be exposed to risk to life and limb. Now, I think this is probably just another way of arriving at the same conclusion or the same endpoint, but there are established threshold tests. And in Officer L, the House of Lords held that the Article 2 threshold was the same as the common law threshold.
Yeah.
Now, we haven't talked much about this, at least until Ms. Fottrell made her submissions, in which she emphasised the convention threshold of an interference with psychological or physical integrity. But it may be that that's another another route, rooted.
Yes.
Is that case in the bundle?
Noticed. The exception that applies there is the need to depart from open justice where
Yes.
it's necessary to ensure that the administration of justice isn't undermined by doing so. So that participants, Officer L, as you know, was about
Yes.
witnesses in the Omar bombing inquiry. So that these were people whose lives were potentially at risk. Seems to me that may be another way to the same kind of conclusion, where you get a very elevated threshold before you anonymise someone who's a participant, and maybe a reluctant participant.
Yes.
And if the threshold is that high for a witness, it's hard to see how it could possibly be lower for a judge.
I would agree with that. So whether the hook is Section 6 or parents patriae jurisdiction or development of the common law, as perhaps there has been in respect of the latter in relation to the jurisdiction to make orders preserving the anonymity of guardians specifically, as was seen in X and Y, that arguably was a development of the common law because it was so freestanding, and one can look at that. It may be helpful to.
Sorry, what are we looking at?
To look at X and Y.
X and Y.
Yeah, we got it yesterday.
This is
One we got
Mr.
yesterday.
Justice MacDonald.
Yeah.
Mr. Justice MacDonald.
Sorry, let me just get it, because I'm afraid I fear oh yes, I have got it. No, that's the one, the other X and Y.
Got it yesterday morning.
I think you sent it to me, so I'll
Did I send it to you?
so I'll send it back to you on email.
Yeah, I've got it.
Got it?
And
Yes, I've got it. Which paragraph?
paragraph 65, and the judge, it's fair to say, Mr. Justice MacDonald does not address squarely the question of the jurisdictional foundation, but plainly finds it. But at paragraph 65, considers specifically the guardian's reputational rights as protected by Article 8. And the question might arise as to how that analysis could feed in any way other than a development of the common law for the protection of a specific person caught up in proceedings. I use the word caught up to emphasize that they are not, they were never the subject matter of the proceedings, like the child or arguably the child's family.
Well,
But-
how does that paragraph help us?
It doesn't give an answer to the jurisdictional question because, as I say, Mr. Justice MacDonald didn't address it because it was assumed to exist. But in answer to Mr. Lord Justice Warby's point, this could be an example of a common law development. And what this really is going to is the question of the threshold at which the Article 8 rights might be engaged for a judge, if there is that jurisdiction to consider them, whether under Section 6 of the 1998 Act or through some other jurisdictional avenue.
I mean, you see the reason I'm interested in all this, because on one analysis, the judge was totally justified in considering everything in the case, including the anonymization of judges, and therefore what he did was quite normal part of the exercise of extending Section 12 protection for the purposes of protecting the children.
Yes.
And maybe he made a procedural error in not asking for loads of submissions about it and further hearings and so on, but he didn't do anything wrong apart from that. That's one analysis. The other analysis is that when the idea came into his head, he should not have allowed it to gain ground. He should not have asked for further submissions. He should not have made an order of his own motion, and that he had no jurisdiction to do that because nothing before him suggested that the threshold, that is a very high threshold, as we all agree, having heard Miss Fottrell's submissions yesterday, had been reached. Now, if that's correct, then it impacts on Mr. Verdon's submissions about the question of hairs running. It means that judges in this position will not be forced to consider about the anonymization of judges at every turn, and they will generally be quite happy to assume that judges are named in these courts, because that's what happens. And if they want to be anonymized, somebody has got to come and say and give jolly good reasons why that is to happen. So it matters, the threshold and the jurisdiction matters in this case. And if we get that wrong, well, there's always the Supreme Court, right? But if we get that wrong, we won't be doing anybody any favors, which is why we've asked for your assistance.
Yes. But if Section 6 is engaged, which it must be, at the very least, then it's an Article 8 analysis, and it's a threshold issue. And so, yes, we heard yesterday submissions from Ms. Fottrell in relation to that. But if the threshold is lower than, as I would submit it may well be having regard to the Montenegro case, if it is slightly lower than the need to show within the context of Article 8, approaching Article 2 or 3 evidence of harm.
Well, I mean, the threshold issue is not that difficult, I think. I mean, Article 2 threshold is jolly high.
Yes.
But it's possible, as we know from the authorities that we were given overnight, that the Article 8 threshold may be slightly lower, but nonetheless high for the question of physical or psychological integrity, which nobody in the European Court of Human Rights has defined very carefully for us. But undoubtedly, that threshold is very high. But the difficulty in this case is not that Section 6 analysis, but it's whether there is any other analysis the judge should have been looking at So it's the inherent jurisdiction analysis, if there is one, and so on, that seems to me we can't just, or the common law analysis, as my lord says, which I think is a very good point to remind us of, because the common law's still there despite all these statutes, including Section 6.
Yes. Can I take your lordship to the Montenegro case?
Yes, of
on
course.
the threshold point?
Is that the Spadia case?
Sorry,
Is that called Spadia?
that's correct.
Which paragraph of that? What's the case about?
The case is about an allegation that someone who had suffered bullying and other abusive behavior at work did not find sufficient protection in domestic law. And we see at paragraph 70, for a start, the point...
70.
70, page 12 of the report. The argument that the Montenegro government were putting forward in response to the case, that in effect it was a relatively low-level form of psychological impairment, one might put it. But the way the applicant put it at paragraph 74 was that the ill treatment at work had violated her dignity, honour and reputation, as well as her personal and professional integrity, which was how bullying was defined in the relevant legislation. It had caused her considerable mental, social and psychosomatic problems, which had ultimately led to a permanent loss of working capacity. And in respect of admissibility...
But she'd been forced out of work.
Yes.
That passage suggests it was a breakdown which had led to her inability to work from the age of 37.
Yes, I'm not suggesting that the facts
No,
are entirely
quite
aligned.
striking,
but-
quite
yes.
strong facts.
Yes. And that point feeds through, my lord may see at paragraph 81, where the court confirms that in order for Article 8 to come into play, an attack on a person must attain a certain level of seriousness and be made in a manner causing prejudice to the personal enjoyment of the right to respect for one's private life. Not every act or measure which may be said to affect adversely the moral integrity of a person necessarily gives rise to such an interference, i.e., plainly there is a threshold, but nonetheless, in that case, it was found that the treatment complained of was sufficient to surmount the threshold. That's paragraph 83. And
What was the concrete act of physical violence referred to in paragraph 82?
I think there had been an incident of physical violence. What I wanted to refer your lordship, my lady, to was the concurring opinion of Judge Yudkiewska, who, and this starts at page 22 of the report, who plainly is potentially troubled by the proliferation of, or extension of, rights protected by Article 8, appears to have given anxious scrutiny to that point. There is reference to the humiliation felt and distress felt, the psychological problems experienced.
Which paragraph are you at?
Paragraph 2 of the concurring opinion. The reference at around 2/3 of the way down the page to the opposition that judge had put forward to the proliferation of fundamental rights. And then in the middle of the next page, you'll see that reference is made to the expansion in recent years of the protection of the personal sphere to include virtually all aspects of an individual's physical and social identity.
Sorry, I don't know where you are.
Page 23, middle of the page, it is noticeable that
Yes. I mean, she'd been told to lose 50 kilos, this person, and she'd had her windscreen smashed,
yes,
apparently. Yeah.
and at the bottom of that page, the quotation that begins, human dignity is harmed when a person is marginalized, disregarded, or degraded. The reference to traumatic experiences. The next paragraph, a reference to the fact that the margins of violence and of trauma are becoming blurred. And then quotation is given of 2 recent judgments relating to bullying.
So you say this kind of analysis can read across to a position of a judge and should what have led the judge to consider very carefully whether the threshold had been crossed?
My Lord, what I'm suggesting is it is a question for the court, and I'm not putting forward a positive answer to this, of course, as to whether in the world in which we live today, where it is common knowledge that the possibilities, the likelihoods of social media firestorms can be so extreme, including trolling, vilification, abuse,
Yes.
that it can result in the possibility of a spillover into actual physical violence or in a way that cannot ever realistically be risk assessed. The question is whether that factual circumstance, i.e. the possibility or likelihood or probability, however one assesses the necessary test, is sufficient to meet this threshold as set out in the Montenegro case.
And what do you say about the consequences if it is?
If it is, and I entirely hear your lordships and my ladies' concern, as I think has been identified, that if the evaluation of a judge in Mr. Justice Williams' position is that the factual circumstances are such that that threshold is met, you set a hair running if you contact the judge and say, what do you think? Or you set down an evidential hearing for the evaluation of it, that is, in reality, impractical.
Sorry, what's impractical? To set the hair running?
It's impractical, one might conclude, to set the hair running, and that's for 2 reasons.
But I mean, if it's legally required, I mean, this is our conundrum.
Yes.
If it is legally required to set the hair running, I mean, obviously, procedurally, I think probably all agree that you can't decide matters that are difficult and complex without hearing argument on them and calling for any evidence that is relevant. But simply to say that it's impractical to set a hair running is not good enough if the jurisdictional hair exists and the threshold is crossed. I'm sorry to make it sound so convoluted.
No, my lord, I entirely, and I have grappled with that point. And obviously what this case engages with is not only an extreme case, and I will come back to that point in a moment, extreme on the facts in terms of the heinous nature of what underlies the matter coming before this court, but the peculiar set of circumstances where a judge may or will find it very difficult because of the particular constitutional and ethical position occupied by a judge to put forward a positive case. And that is a very difficult conundrum for this court to deal with, because, and this is why I say the setting the hair running is impractical, because what would it in likelihood result in if the response is, as has been seen by the judges in this case, I don't feel able to say anything? Mr. Justice Williams, in that scenario, would have been in no better position. And it perhaps links back to a point that my learned friends have made, that judges are expected and presumed to be men and women of fortitude, which no doubt is correct. But those were words said by Mr. Justice Munby in 2001, at a time when the world was a totally different place.
But I don't think anyone's suggesting that a judge who receives a direct, immediate, completely convincing threat that they will be murdered is constitutionally required to say nothing about it to anyone and leave, or that their family will be murdered because of something they did. So there must be situations in which the self-restraint that we're all required to adhere to is limited. It doesn't necessarily follow that anonymity or asking for it is the solution, but that normally there'll be other measures that will be more effective.
But the argument, my lord, is in relation to, or maybe in relation to, I'm not putting forward a positive case in relation to this, but where the risk of online abuse and vilification is so extreme as to engage Article 8, are judges expected to tolerate that? And yes, of course, the threshold is high. Judges are no doubt expected to tolerate more than other employees, other workers, other people involved in a case. But are they expected to tolerate trolling and vilification? The possibility of that trolling and vilification spilling over into actual physical violence. That is the inherent difficulty, and that is why a potential solution to the case lies in the extremity, the potential solution to the conundrum this court faces, lies in the extremity or the extreme nature of this case, and that it is the underlying facts of what has gone before that informs the Article 8 analysis.
But that requires, doesn't it, the court second-guessing what may come out on social media? Because if it's already happened and you can say, this poor judge, this is just horrendous, no one should put up with that.
Yeah.
Well, the cat's out of the bag anyway, because the judge has been named and all that opprobrium has landed on his or her head as a result of however they handled the case in the eyes of those on social media. So, given that this is about naming the judge, and as my Lord Justice Warby says, you know, other routes, security, police, injunctions, whatever, we're talking about a state of affairs where you're considering before it has happened.
Yes. And there is a clear difficulty with that.
Well, you've got to second guess who's out there on this particular case that's going to...
Yes, and that, it comes back to my Lord Master of the Rolls' point yesterday in relation to judicial notice, and plainly there is a procedural issue in this case as to the extent to which, and no doubt he should have done, but Mr. Justice Williams should have given notice to the parties of what was going through his mind. But is it possible, I pose rhetorically, for a court to take judicial notice of the likely social media storm that results from factual circumstances of this nature? In other words, where one has a case as extreme as this in terms of the underlying facts, coupled with the nexus that social media will unfortunately draw to the involvement of the family court in the historic proceedings are those factual circumstances that enable the judge, as Mr. Justice Williams did in paragraph 76 of his judgment, 76, to conclude that the likely level of online abuse will be high without having had any kind of external informative evidence or risk assessment.
Sorry. My lady goes first.
Well, on one view, you don't need the judge's views in that case. If you're saying, you know, I'm looking at the generic situation with social media, one, I'm looking at this, the facts of this truly horrendous case, two, and these judges dealt with childcare proceedings in a case where ultimately his child died. That's enough.
That is one answer. That is the natural corollary of the submission. I see that.
Yeah, and if that's an answer for this kind of case, is it really right that it's exceptional? Maybe exceptional on its facts, but is it exceptional as a category of case? Think of the diplock courts, where juries didn't sit in Northern Ireland because of the risk of interference, but the judges sat and decided terrorist cases, and they were named. No one seems ever to have suggested that that shouldn't happen. There's a whole range of other circumstances. SIAC has been mentioned on that side of the court, where people decide cases which may be highly controversial, involving people who may get very agitated and may have access to the means of inflicting violence on those whose role in the proceedings they don't like.
Yes.
So I find it difficult to see that the exceptional nature of the specifics of this murder case and the fact that the family court was involved with the family concerned puts it in some special box that wouldn't bleed into a whole range of other cases if we were to approve that approach.
I suppose one answer to that is that it does involve, this case, it is extreme and exceptional in that it involves something so terrible that's gone on, and then involvement of judges in the historic proceedings, and it shines a clear light on those people, on those judges, in contradistinction to the diplock courts or judges sitting in SIAC proceedings, where a conclusion as to a possible social media storm as a result of those is more difficult to see.
Can I ask you this? It seems what you're saying is that the court has to consider whether life has changed materially so that the procedural approach and the jurisdictional approach is affected. So that if we are to say that it is appropriate for a judge to do what the judge did, namely consider, I mean, I'll leave on one side of his own motion, but consider that a social media storm is likely in an exceptionally aggravated criminal case background against a aggravated criminal case background, and that therefore measures may be needed to protect not only workers in that family environment, but also judicial office holders. Now, that would be a very great change to the open justice principles of common law that this court and the Supreme Court have expressed very often. But, I mean, it's precisely the reason you're here, Mr. Tysack, is because we want to make sure that we're not missing something if that is truly the position now. Because it obviously is not completely invalid to say that media, particularly social media storms, erupt with great intensity now,
Yes.
and much greater intensity than ever used to exist. But how do we judge whether things have changed so much that the law must keep up with them?
Well, my lord, this is why I was referring to the separate opinion of the judge in the Montenegro case, because that
Yes.
concludes at the end of, right at the end of the judgment at paragraph 25,
Page 25.
page 25, sorry, page 25. Firstly, at the top of the page, a clear reminder that not every interference with human dignity reaches the Article 8 threshold, but only those that have a serious effect on the psychological integrity of the victim. And then in the penultimate paragraph, protection from bullying as an attack on human dignity, actually the very aim of bullying is dehumanization and destruction of human dignity in the modern world, would clearly relates to a minimally decent life. And the requirement, the concluding words, for the court to reflect societal changes. And that chimes with the obligation for domestic courts to keep pace with the convention jurisprudence, nothing more, nothing less, of course, but the argument may be that this court cannot ignore the changes in the world in the last 20 or so years, and in therefore modifying or adapting or developing procedure accordingly, that is a necessary result, is the argument, because the state's obligations to protect a judge's Article 8 rights are not obviated by the fact that the judge may not be able to advance a positive case in support of their protection. And the inability to assess in a quantifiable way the likely risks of a social media storm does not mean that there is a risk of a social media storm. It is it's an impossibility
I've
of life.
noted that down because I think it's very important. You submit that the state's obligation to protect the judge's Article 8 rights are not obviated by the judge's inability to make their own submissions in the context of the known risks from social media, effectively.
Yes.
And so really you're saying that this or any court has to be brave in recognising that potentially stands in the way of the juggernaut of open justice and in family proceedings, the transparency.
My lady,
Because
yeah.
obviously it's completely contrary to both of those concepts to start anonymising the names of judges for the first time in the history of our legal system.
Absolutely, I would not demur from that at all. And clearly it would engage the proportionality principle. And I think I made the point in paragraph 22 of my submissions that is relevant in that regard.
Which paragraph, please?
Paragraph 22 on page 7. Plainly there is, and it amounts to, a significant change in the presumption, in the standard state of affairs that the judge's name is public. But it is a curtailment, but it is not a shutdown of freedom of expression or the right to report. I wouldn't, of course, suggest that any of the submissions made as to the open justice principle yesterday or transparency were wrong. And insofar as Mr. Justice Williams made reference to, for example, shielded justice, that is difficult to support, one might conclude, from the authorities and from the clear terms of Section 12. But putting those issues and that terminology aside and looking at the ultimate determination of the judge at the end of his judgment, the court might conclude that the exercise that he in the end took was one within his discretion.
And you place some reliance at paragraph 22 on the fact that this is a perhaps stronger case, is this the point, than Abbasi? Because in Abbasi, if the order had continued, all debate was foreclosed, whereas here, legitimate debate is not in any sense foreclosed. The only thing that is foreclosed is perhaps naming and shaming, or naming and making allegations against the judges, which the judge himself has already said very clearly are not justified. The judges bear no responsibility for anything. They did what every other family judge would have done.
Yes, and I would add to that point, my lord, possibly by the submission that if in redacted form the judgments are released and circulated, and there is a wider public consideration of the nature of those decisions, and then the review in front of another judge were to take place, as Mr. Justice Williams did set up, there may be the possibility of a renewed consideration of the issue when the underlying facts are more widely known, and therefore
Although that does stop the immediacy of the media interest, of course.
yes, and that's I entirely acknowledge that, and the commodity point is a good one, but it's not necessarily saying it's never.
No, and Mr. Larazade made an interesting point, because he repeatedly said, well, it's not just the names, it's going to be pictures all over the press, potentially. And is that, I mean, I think what he was saying rhetorically was, is that right? In the circumstances where nobody's really can justifiably say they did anything wrong.
But the question I would have about the judge's ultimate balancing approach is whether he started in the right place. People often cite paragraph 17 of In Re S as if it was all that Lord Staines said. But what he also said was that given the weight traditionally given to the importance of open reporting of criminal proceedings, this was what Mr. Justice Headley said at first, referring to what Mr. Justice Headley had said at first instance, it was appropriate for him in carrying out the balance to begin by acknowledging the force of the argument under Article 10 before considering whether the right of the child under Article 8 was sufficient to outweigh it. And decisions of this court have said that's the right approach. You start with the open justice principle, and then you consider whether the Article 8 rights or the other convention rights that are put forward make it necessary and proportionate to interfere with that principle or the Article 10 considerations which sit alongside it. So what the judge did here on one analysis is to start by demanding some specific need to know the names of the judges in order to conduct what he would regard as a legitimate discussion of the merits of what happened in the family court. So arguably that was an error. That's the question for you.
My lord, insofar as the judge did that, I would agree. It's not a clean sheet, and it's certainly not tipped in favour of not naming the judge. Plainly, there must be a presumption of the judge being named, and the upholding of the open justice transparency principle. But it is right to note, in fairness to Mr. Justice Williams, that he does make a number of references to the exceptionality of the step he's taking.
Yeah.
And put another way, that is imposing a presumption on the naming of the judge. Now, whether it was whether in his mind the correct test was being applied.
I think he said specifically that he wasn't doing that, didn't he?
He says at paragraph 75, that not naming the judges is an exceptional step. And he also says at paragraph 78, I think it is, yes, when the balance comes to be applied to the judge, the expectation would be naming. That's 4 lines from the bottom. Perhaps it could be said he isn't putting it high enough, but he's applying a presumption of naming, it appears.
Mr. Submissions were made this morning about the possible tests using terms like exceptional circumstances, high thresholds, significant risk, etc., threats, blah. I can't remember the precise words from Mr. Verdun. What do you say the test is? It must be possible to formulate the question that the judge ought to ask himself before he either starts the hair running or dismisses the question. And I don't think anybody's really done that except to sort of bandy around, if I can put it this way, legal words that you put in everybody puts in a different order, depending on where they want the bar to sit. But I think there has to be the possibility of distilling both the European Court of Human Rights Authority and domestic authority under the common law into the situation that the judge has to see as realistically possible before, as I described it yesterday, the box is opened. Because I think we all know it is not particularly desirable to set up a new procedure which is lengthy, time-consuming and costly within the family courts, let alone all the other courts, about the naming of judges in difficult and complex and perhaps aggravated cases. So I'm searching for the question, the correct question the judge should have asked himself before I come to the question of what the answer was. You don't have to do it on the hoof. But if you do have a view about that, or you feel that it is really possible to distill the learning in the cases that we've only really looked at since we asked since Ms. Fottrell's submissions, it would be helpful to the court.
Yes, my lord.
I don't want to bounce you, Mr. Tyzak, and I don't want you to feel later that you've been bounced. So say whatever you think appropriate.
Well, my lord, certainly happy to think further about that. One difficulty I foresee with trying to formulate the test by reference to the European authorities is that, as I've been submitting, the risk is inherently tied up with the particular extreme facts of this case. And how that fed into Mr. Justice Williams' mind features at paragraph 83. 81 and 83 in combination.
Sorry, let me look at them again.
81 is a clear anchor to the underlying facts, and the court may feel is not an unreasonable anchor.
So you say we shouldn't take against him on the basis that he talks about the evidence set out, because that's just a slip of the tongue. What he means, the situation I have described, which is in the modern world something different from the cases that we previously rely upon, means that.
My lord, yes, and one may conclude that the examples he offers of the serious events that have gone before in relation to other judges and attacks and so forth are not evidence. They are illustrations the judge is giving of the current climate in which judges are operating today.
Well, he's sort of taken it as evidence. If you look at paragraph 76, effectively makes a finding when you look at the paragraph as a whole, what he regards as a real possibility of violence.
Yes.
The judge is named.
I don't disagree with that.
But
This
I suppose
court-
he could be using violence in the sense used by the dissenting judge in Spadger, where, you know, I mean, it's a very interesting judgment, that, and I'm certainly grateful for you having drawn it to our attention.
Yes.
Because it may be the first time I've seen written down an acknowledgement that values in our society have radically changed, that things have radically changed. And he may be using the judge. I mean, we don't want to be unfair to the judge. He did all this incredibly quickly, and incredible dedication to duty in writing this lengthy judgment in that short period. So if he got evidence and, you know, maybe may have even have overstated the case, we shouldn't hold that against him.
No, he's plainly a judge in a leadership position, or has been in a leadership position, with knowledge of the circumstances facing judges that he has had oversight in relation to. I don't want to stray into making submissions about which things I do not know, but one interpretation of the way the judge puts that is it's an illustration of the circumstances of the climate.
You see, the question that comes into my mind again and again here is how relevant is it that it would all be terribly inconvenient if he were right? Because we would be setting up some, we'd call it hares running or new procedure, and there would be lots of cases, putatively, in which the same situation and decision would have to be made. Is that relevant at all in the balance, or is it something we should discount? The practical realities of setting up what appears to be a new and inconvenient consideration.
My lord and my lady have to decide the case
But is it
before
irrelevant
you.
as a matter of law, is the question?
The answer to that may well be no, if this judge's, or these judges' Article 8 rights are, upon proper evaluation, infringed.
Sorry, by no, you mean yes? The answer may be, sorry, no,
Yes.
it's not irrelevant, yes.
Yes.
It is relevant.
think you're
It may
saying it
be
isn't.
relevant.
I think I was going to submit that it isn't a relevant consideration, the
It
practical
isn't a relevant
difficulties.
Not even within the proportionality analysis?
If the Article 8 rights are potentially infringed, and that is the ultimate evaluation, then an Article 8 rights being personally protected rights, with the state's obligation to personally protect those rights.
But doesn't it depend on what the mechanisms are and the range of possible outcomes? If the right view factually was that it's going to be only in rare and exceptional cases, that the threat to Article 8 rights reaches the necessary threshold, however one defines it, and there is a range of other ways in which those threats can be, and maybe, as a matter of fact, are addressed, then the need and proportionality for an entirely new system to evaluate hundreds and thousands of cases for Article 8 compliance would be hard to see.
My lord, yes, but is that foreseeable? Is that possible? Might be the response to that, in the sense that if the court is confining this to truly exceptional cases, mirroring a factual scenario seen in this case, which is, to pick up on my lord Master of the Rolls' point, a factually different scenario to the Abbasi case in very significant ways, the door is open, but it's only open by such a small margin that to perceive of there being a floodgates may be felt by the court to be of limited risk. I don't know if my lord and my lady saw it as I was passing through the Montenegro case, but there is quite a helpful reference in relation to the societal change point on page 23 that I didn't specifically identify, that is social advances requiring evolutive interpretation, and that must include the procedural and substantive rights.
Sorry, where is that? Social advances require evolutive interpretation. The living tree doctrine.
And of course, the convention is a living instrument.
Yes. Well, the convention is a living instrument.
Yes.
Yeah.
And one argument is that ultimately what much of this boils down to is the extent to which it was open to Mr. Justice Williams to appraise that the social media firestorm in this case was such as to give rise to a clear and imminent risk of serious infringement.
I mean, it's very hard for a judge to, I don't know whether, many judges don't even use social media. So pretty hard to do it without any evidence or any submissions.
That is the challenge, but...
Except sort of anecdotally, or which is not really an appropriate thing for judges to do, is it?
An answer to that might be, to what extent is an assessment of the modern world, of the reality in which all of us live, evidence or just life? And if media firestorms, social media firestorms, and the risks that arise, trolling and vilification, words that were certainly in respect of trolling were not even in parlance in 2001 or 1987 when relevant cases were decided.
In other words, judges expect to know who are the Beatles.
Yes. Yes. It's not... it's not evidence. A judge couldn't call evidence in relation to that. What evidence could possibly be called? Expert evidence in relation to the likely firestorm? It's hard to see that that would be of any assistance to the court.
Well, otherwise you're just making it up, aren't you? I mean, it's just, you've got to find some facts in order to justify the exercise of these weighty powers. If you don't have any evidence in the normal sense from someone other than the judge can take judicial notice, but only, as I understand the law, of those facts which are so notorious that everyone knows them and it's pointless and wasteful to demand evidence. You can't take judicial notice of what you've seen on the social media and regardless of whether you've told people what you're going to do with it or what you have in mind. You can't just... It's not the way that judging functions, is it?
No, no. And the judge clearly hadn't seen any examples. He hadn't seen any posts. There'd been no production of evidence in relation to any social media posts. So it's not that that's being relied on. It's a...
And I don't really see how Joe Cox's fate could realistically be linked with this case, except in the most general and blurry sense that there's a person in public life about whom someone else had feelings so strong that he killed her for what she had said. But that's very general and very remote.
Yes, again, it's an illustration, perhaps not evidence that the judge called upon. A better example might have been the Southport riots that, it has been widely reported, were prompted as a result of posts circulating on social media, misreporting the identity of the person who committed those terrible acts. There are obviously many examples one could point to of the ills of social media, and that may be putting it relatively mildly. The other point that perhaps is of relevance in the evaluation is the impact on judges' families is plainly included within the content of Article 8. And if we get to the hurdle of online abuse and vilification and trolling, engaging Article 8 and being of a sufficient threshold, then the impact on family members plainly may arise as well. Rest that is, of course, a much more difficult question, but it exists, and it is another result of the obligation of the state not falling away by the difficulties in the evaluation.
Where does the need for judges to be resilient come into the equation?
In my submission, that comes into the equation in the evaluation at which the threshold is set under Article 8, which must be high, but is not so high so as to exclude any possible right protection. And it may help to go back to Harris on this point, which is at page 65 in the authorities bundle, paragraph 372 of the judgment of Mr. Justice Mumby. Certainly not a contempt of court to engage in reasoned criticism of the judicial system or the judiciary, whether that criticism be of an individual judge or of the judiciary as a whole, even if that criticism is expressed in vigorous, trenchant, or outspoken terms. For that which is lawful, expressed in the temperate and scholarly language of a legal periodical, does not become unlawful simply because expressed in the more robust, colourful, or intemperate language of the tabloid press, or even in a language which is crude, insulting, and vulgar. Judges, after all, are expected to be, and I have no doubt are, men and women of fortitude, able to thrive in a hardy climate, and the vehemence of the language used cannot of itself measure the power to punish for contempt. Noticeably absent from those words is the short but significant word abuse. Yes, judges are assumed to be broad-shouldered, but are they expected, I ask rhetorically, to tolerate abuse?
Well, he does use the word abuse in the last but one line.
Ah,
You're talking about the past, when judges used to regard certain criticisms as scurrilous abuse. So he's using it by way of contrast.
yes, yes.
He's certainly not talking about physical violence.
And the difficulty in making it a personal-based evaluation, i.e. calling to the particular judge, perhaps if Mr. Justice Williams had invited a response from the judge before any publication was made. The difficulty with that is that some judges might be more broad-shouldered than others. Some judges might be prepared to accept the risk of an infringement of their Article 8 rights for various reasons. But that doesn't, again, obviate the obligation on the state to protect them, particularly if those rights are being infringed in the course of the judge's performance of their judicial functions.
Well, the Strasbourg jurisprudence has plenty to say about the need for public figures to tolerate a much higher level of criticism than purely private persons, and that must apply as much to judges as it does to politicians and other
Yes.
people who place themselves into public positions.
Yes.
And I suppose it would, and that the jurisprudence tells us that even so, public figures have a right to a private life. So the threshold is higher. And I think that your submission it sort of recalls that aspect of Strasbourg jurisprudence that says that interferences mustn't be such as to impair the very essence of the right.
Yes.
So there must be some point at which the state has some kind of obligation.
Yes.
I mean, the difficulty is this, that in the modern environment, it could be said that some of the language deployed on social media is much more extreme because the restraints that used to exist on people swearing and threatening are no longer quite as clear as they were years ago. But the difficulty is to have some realistic analysis of when, even in that environment, there is a real risk of physical attack or psychological attack. As we know, it could be physical, could be psychological. But that's incredibly difficult. I mean, I'm just, you know, one inevitably thinks ahead to what if the judges are named and heaven forfend there was some attack, and there have been attacks, as the judge reminds us in his judgment.
Yes.
So one inevitably wants to adopt a protective and cautious approach. But equally, the consequences of doing so are quite serious as well.
Yes. And as we heard quoted this morning from my learned friend, some examples of the social media posts in Annex 2 and the content of those and the violent content of those. Which of those would become reality? Would any of them become reality? Those are imponderables.
Well, many of them are silly. I mean, you know, they're not. They're just silly threats. They're literally in the category of vile abuse.
Yes.
But it's extremely hard and not particularly productive to go through them and say, this one's vile abuse and this one's a real threat.
No.
Because how do you know?
Yes. And there are, of course, only a selection. There may be many others. There may not be many others. But the protection of the right is, of course, not an ex post facto protection. It must guard against the infringement of the right. It's no good plainly waiting to see what happens and hoping it doesn't happen.
But what about the point that my lady has made several times in this case, which is that this is not the only thing that can protect the judges. Obviously, anonymity is one thing, but they can also be protected by the authorities in numerous different ways. Why is that not a sufficient protection, and why does it not make it disproportionate to interfere with the system of open justice that this country has adopted for so many years?
Yes. The first point to that may be that if online vilification and trolling is sufficient to weigh in the Article 8 balance, it meets the threshold, then there isn't really any protection that can be put in place in relation to that. The only answer is perhaps my Lord's point yesterday that one solution is just not to look. But
Well,
plainly
not looking
that's-
is absolutely fine until somebody comes up the drive with a, with a gun.
or it takes on other forms and it starts resulting in emails or telephone calls or not only physical attendance but other form of online trolling that is not avoidable simply by ignoring it. And
But
plainly
that-
there are going to be some judges who are more socially media using, some who aren't.
But that's one of the challenges, isn't it? Because the other means of protection, security, whatever, you've just said, well, if it has happened, but, and those can be put in place there. But what we're talking about here is second guessing whether it will happen.
Yes. And that is why, and
Anonymising the judge is hopeless once the social media storm is out there for the poor subject to it.
yes, it's why, unsatisfactory in some ways though it may be, one evidential way of addressing the issue is by linking it back to the underlying facts of the case that gives rise to the potential necessity for anonymisation.
I don't
And
quite
that is
understand
the-
what you're suggesting. Are you suggesting that in every very serious case, judges should be anonymised?
Where the case is of such facts, such heinous facts, linking with involvement, to put it neutrally, of the judiciary, there is the obvious potential, more than potential, one might say, certainty, perhaps, of online trolling, vilification and abuse.
Yeah.
And if that factual scenario of the underlying case gives rise to that conclusion, i.e. meets such a high threshold of being so likely, then perhaps that is putting the threshold sufficiently high without requiring impractical and impossible evidence of the likelihood of these issues becoming realities, i.e. social media posts turning into realities, but also would have regard to the severity of the psychological impact of such abuse, where it's plainly in an extreme case where things have gone
But
so
I can
bad.
envisage a massive debate about what is an extreme case.
That is the impossibility. I accept that.
You're saying an example may be as here, where there's been earlier proceedings, particular outcome heard by a particular judge, and then subsequently when something terrible happens, like in this case or in Butler,
Yes.
you may need to consider whether you may regard social media storm abuse as inevitable for the judge that heard the first set of proceedings, and that may be one of the rare cases where you do anonymise them.
Yes, that would be the formulation.
Okay, well, you haven't set any hairs running, Mr. Tyzack, but you've certainly set us thinking.
Well, my lord, I hope it's of assistance. Can I emphasise that no case is being put? I was hopeful just to be able to explore the arguments, particularly as plainly a strong case is put for open justice and transparency and naming, and so that the court has all arguments, possible arguments, in front of it.
If I may say so, Mr. Tyzack, you have performed the role you were asked to perform with consummate skill.
Well, I'm grateful.
Absolutely.
Unless I can assist further.
No, thank you.
No, thank you very much. Yes, Mr. Barnes.
My lord and lady, I have a number of short, somewhat more prosaic matters in light of wanting to try and assist as far as I can with our position in relation to the critical legal jurisdictional question as it relates to the Article 3, Article 8 borderline. So if I can deal with the prosaic matters, then hopefully it allows enough time for me to assist. But can I start by flagging where our endpoint will be once I try and assist the court? What happened to Sara Sharif was extreme. What happened to Sara Sharif was exceptional. What has followed on social media has not been anything like exceptional and has not been anything like extreme, and there is nothing to suggest that there would be a particularly extreme or exceptional reaction in this case. And to that extent, the evidence that's been provided on behalf of Mr. Sharif may be helpful rather than unhelpful. And respectfully, we rely on, as I took the court to, the decision of Mr. Justice Nicklin in various claimants and ipsa in accurately, prosaically, judicially, cautiously interpreting what, in reality, social media abuse amounts to. And in reality, it follows through almost never to any genuine physical risk. And so, in a sense, what I was struck by when Learned Friend Mr. Verdon was addressing the court was that when he was considering the question of the threshold tests, the language he used, as indeed my Lord Justice Warby drew attention to in the Officer L case, is precisely the sort of language used under our common law tradition and under the Article 2 and 3 jurisprudence of the European Court. And so our formulation of the question the judge asks himself is there a real likelihood in this case that the positive obligations that arise under Article 2 or 3 might be engaged in this particular decision? And if so, my first port of call is to engage with the sort of institutional architecture that provides the sort of protection that we say should be the first answer before what would amount, if the extreme position is adopted, of an unprecedented and extraordinarily expansive incursion against the open justice
long question.
No. The question is straightforward. Is there a likelihood that the Article 2 or Article 3 threshold in this case is engaged? And then the question, when you come to consider the issue of anonymity, is does the established jurisprudence, those tests that I have to apply, does it actually meet the Article 2-3 threshold? I set those out in my skeleton argument, including reference to the Officer L case, which I think Mr. Nottage has sent through to you. That distills out an absolutely pellucidly clear, extremely well-established test.
Let's look at your skeleton argument then. Which paragraph is it, please?
Paragraph 51, I believe.
'51.
I believe so. Yeah, it's page 40 of the core bundle. Inevitably, in flagging where I intended to go, I've been diverted from the prosaic matters that I will like to return to. Paragraphs 50 and 51, we refer in paragraph 49E to the Nicklin case. We also address at 49D that HMCTS and other government departments have all sorts of obligations that arise before one gets to anonymity. We also throw into the mix what I hope is uncontroversial, which is anonymity in this context is almost never the answer. If somebody is a direct risk to somebody, to a judge, it's because they're likely to know exactly who they are. And that's why we say the reliance on the 3 extremely serious instances of judges being subjected to criminal behaviour informs why anonymity in this context as a prior restraint is not the answer. And it's also not the answer because it raises suspicion, it raises the temperature, and it does nothing to assist confidence in the judiciary overall. It is, as we said to Mr. Justice Williams when we invited him to review his decision, an utterly corrosive misstep. Now, my clients bring this case pursuant to what they see as an exceptionally important public interest, which is given significant protections under Article 10, that fully incorporates the open justice principle, but they are not blind to the fact that the state, who they seek in various measures, along with their journalistic colleagues, to hold to account, have certain obligations when exceptionally serious threats are raised and appropriately high thresholds are met. That was the basis on which we made that active concession within this case, that of course, if the Article 2 or Article 3 threshold is met, then the answer may be different. We don't say that anonymity is necessarily the answer to that, and the experience in Northern Ireland, we would say, compared to a level of social media reaction here, that rather points to why the category error of transposing what happened to Sara Sharif as being exceptional or extreme to what is happening to the judge, which is the focus of this question, doesn't put it in extreme or exceptional category when one is dealing with, on the other hand, a judge sitting dealing with a terrorism trial.
Well, I mean, the high point of the submissions on the other side were really when Mr. Tyzak, who takes no position on the outcome of this case,
Understood?
suggested that the judge's analogies were not necessarily the best ones, but you could make an analogy of social media being put into effect from the riots last summer, I think. And so do you say that, I mean, you went as far as to say that there was, I think, you said no, you said there was never a genuine physical risk. Do you maintain that? Never a genuine physical risk just because people say silly things on social media.
I think the issue is, it was what Mr. Justice Nicklin dealt with in the various claimants in its case. It may assist to return to.
Which page is that?
Page 269.
I believe it's 2.8.
My lady's saying 269.
That's the beginning.
That's the start, yes. I was looking at 2.86. And I would respectfully suggest that the analysis of paragraph 52 is the temperate, properly informed analysis of what follow-through exists. And of course, the court might take notice of the developing trend of social media interaction and engagement, but it also has to take judicial notice of the fact that those threats are rarely, if ever, followed through in a meaningful way for precisely the reasons that my Lord the Master of the Rolls has highlighted, that anonymity may well give rise to a cloak of feeling able to say things that one would in reality never do. And particularly if one is located in Texas and dealing with a judge in this jurisdiction, the degree to which that follows through must be exceptionally questionable. So,
I mean, to summarize, you reject the idea that we should re-evaluate the old authorities, Felixstowe and Harris and so on the basis that life has changed.
life may have changed in the modern world, but in reality, if one is dealing principally with the risk of physical violence as the central grounding point, then I'm not sure that the contours of that debate have radically changed. Because whilst social media backlash may be a more realistic part of modern life, there isn't a general laxity towards a toleration of physical violence.
No, What do you
or a
say-
tendency towards that to a greater degree than there has been in the past.
What do you say about the Montenegro case and the analysis that our tolerance in modern society of conduct that perhaps was more acceptable years ago, like bullying causing psychological damage to people? So the threshold in modern life has changed a little, and it's not just physical violence. We know from the European Court of Human Rights authorities that the physical or psychological integrity of people can meet an Article 8 threshold, not just actual physical violence.
In sparing an extreme
We know it has
circumstances.
to be in extreme and exceptional cases, and we get some colour to that from the Montenegro case that Mr. Tyzak helpfully drew our attention to. And the question I have is, how does that fit in with the suggestion that social media really can't cause the physical violence necessary to reach the threshold?
Okay, can I respond with 3 points? The first, in relation to the Montenegro case, is that was grounded in actual real-world consequences that had been suffered, and there is a distinction to be drawn between anticipated future risk versus a defined, established harm. Secondly, insofar as the European Court has developed the jurisprudence around Article 8 cases, physical, psychological integrity falling just short of the Article 3 borderline, that is often associated, and I would say generally when one has regard to the material that the local authority has put before you, of particularly high levels of vulnerability in the individual concerned. And that's where the relevance of being a child in relation to corporal punishment, being the survivor of sexual assault is relevant to opening that narrow gateway under Article 8.
Judges are not subject
Precisely.
to a high level of vulnerability, but what about their families?
Well, I'm afraid that, again, one is talking about levels of speculation distance that ultimately get away from what the issue is in this case. And can I frame it in this way? The position in this sort of case, where one is dealing with a relaxation of reporting restriction to allow information relating to the proceedings to be reported, in relation to the judge, respectfully, that is a non-decision. They were able to be named before, they were able to be named after, they were publicly known before, they should be publicly known after. So the degree to which there is real engagement with those rights is fundamentally distinct from a position where a child has protections under Section 12, and those protections are being relaxed to afford the opportunity to report. And that, in my submission, is part of the answer to my lady's question about the applicability of Practice Section 12I. A relaxation of reporting restriction is not a reporting restrictions order. It is the opposite end of the telescope. And so it engages the Article 8 rights of the parties involved who have to be on notice, but not the entire media expressing the broader Article 10 rights that are engaged, which requires the sort of process that's outlined in that practice direction. And if one sees that it is a non-decision, then essentially the question becomes more straightforward to analyse. And again, what I think there was a danger of in Mr. Tyzak's submissions was in narrowing the telescope to a family jurisdiction. Now, I say the Sharif case is one of the most extreme cases of treatment to a child where there is an intersection with prior family proceedings having happened. And my lady's case in respect of Ellie Butler is another. But if the actual follow-through, even on one of the most extreme cases that might come before a family court or come to attention in this way, doesn't in fact lead to a set of extreme or exceptional circumstances that engages either Article 2 or 3 or Article 8. The far more likely scenario in which a judge might require specific protections is, in fact, the sequence of examples that the judge gave, which is a grossly disgruntled litigant who, for whatever reasons, behaves utterly inappropriately and either harasses them and so on in a way that is described in the Harris case or infringes the criminal law. And again, this is why the starting point that I came at when I was trying to define the shape of our case applies. We don't say that judges abrogate Article 8 rights in all circumstances, for all time, on taking judicial office. They plainly don't. But, as my Lord the Master of Rolls pointed out, there are a whole system of other mechanisms to preserve and protect those Article 8 rights, including the judge and their family. That includes proper guidance, proper risk assessment, proper protections where they may be required, proper application of genuinely available civil and criminal law remedies. And all of those can be undertaken without any infringement of the open justice principle that in my submission goes towards the question of, should this court, without any prior justification for doing so, and in fact in a manner antithetical to the common law tradition, say that in this jurisdiction, applying the margin of appreciation that we enjoy in how we go about preserving the rights under Article 8, that our response is not anonymity for a judge in a prior restraint manner in this sort of case?
Well, you say, very simply, I think, that it's very undesirable to open the box when nobody has asked you to open it. And in order to open the box, you have to have a very high threshold of evidence, or perhaps you might accept judicial knowledge that relates to real threats to the judge in question, not just to the fact that social media is a dangerous place.
And that is Article 2 and 3.
And that's
I agree.
Article 2. Well, if it's not Article 2, it's physical and psychological integrity as interpreted, meaning a high threshold, even in the light of Montenegro.
I do not make that concession in relation to judges in the context of naming them in their public function with no other regard to their private life at all.
No evidence.
We're not giving them the telephone numbers, we're not giving them the addresses. And also, I should say, there are many aspects of Mr. Justice Williams's judgment, and indeed some of the anxieties that the judges express, which point to a real need for HMCTS to engage with their obligations to provide adequate risk assessment and protection to not only those judges who might be encountering potentially violent individuals, but anyone walking in the court arena, working and operating in the court arena, who might have to engage with them as well. I don't know
Can I
that
just ask you how, I mean, I sort of understand the attraction of limiting it to Article 2, Article 3, and real risks to the judge in question. I completely see the attraction of that.
It is a hard-edged and established test, I think, is helpful.
It's a hard-edged and established test, which is helpful. We can all agree, anyway, it would be helpful if it were right. But the question I have for you is, on authority, Article 2.3 is not the end of the story, even if Article 2.3 thresholds of real risk is not reached. Anyway, the European Convention, or European Court of Human Rights authorities, say you do have to look, because it is possible for something that doesn't reach the Article 2 threshold to interfere with Article 8 rights. Now, I think what you're saying is that cannot be the case in the case of a judge in, I was going to say an escrow, but it's not a very good word, without concrete evidence of risk to that judge in that case.
Well, that's my answer. That's my alternative submission. If my lord is not with me that the threshold is Article 3, it is that if you are encountering that narrow territory and applying that range of jurisprudence to a judge in the case of anonymity, then yes, there is absolutely an important evidential threshold to get over. But where I disagree with my Lord the Master Roll's summary is this. That need to consider the potential breach of Article 8 in that context may arise, but it isn't the same obligation because it can bow to other considerations. That is the fundamental distinction between Article 8 and Article 3. Because in this context, Article 8...
Well, because Article 8 is not an absolute right.
Exactly. Yeah. And so when this state, applying its approach to Article 8 protections, looks at the question through the prism of our established common law tradition and says, can we permit of anonymity for judges in this context? I say the answer is, there is nothing to establish that that is required by the European jurisprudence in relation to judges in this context.
Yeah, so you don't you don't accept Miss Fottrell's submissions. So when we all went off yesterday afternoon, having listened attentively to Miss Fottrell's helpful submissions and thinking that she'd shed clarity and light on an otherwise difficult problem, you say, well, no, she hasn't really.
I have to say, I also listened attentively. I also looked carefully at the very helpful material that the local authority placed before this court. And I seek to engage with it genuinely, which is that line of case law tends to be associated with particular issues of vulnerability, as opposed to particular issues of fortitude.
Yeah.
And respectfully, whilst the risks and the nature of what judges or anyone in public life might have encountered, and whilst, of course, there will be a range of individual reactions to something, personal fears, where not substantiated by objective evidence and meeting the threshold, isn't of itself sufficient. And respectfully, I see no basis for an assumption that even in the climate we're operating in, there is less judicial fortitude. In fact, one of the issues that I raise in this instance is that the entire way this judge dealt with these issues demonstrated a failure to apply that standard. Now, that may be because, for reasons of his own pastoral role and his own experience, he is too close to that issue to take the sort of objective analysis that respectfully should be applied in this case. And the fact that he has pastoral responsibility, or had pastoral responsibility, for, in fact, the judges who he has granted anonymity to, I don't say that was deliberate. It is all potentially understandable. What it is wrong in principle and wrong in its application of the law.
But it is bad, isn't it, when judges say we've looked at what they actually said, that they have concerns about their safety.
Yes, my lady will be aware that even in the family division, there has been deprecation of loose language of concerns. One can well understand why, in the circumstances, if one was asked the simple question, would you prefer it or not, you might say no, and you might have anxieties about what yes means. But they have to be objectively justified, and that isn't to...
I mean, I think it comes back to my sort of, my 9th of December point, which is that before the 9th of September, their names were, anyway, notionally in the public domain.
They were capable of being published, exactly.
And so even if nobody knew, they were still in the public domain, or nobody outside the case knew. And you have to have something quite serious to put the genie back in the bottle after that. And there has to be some proper evidential basis to do so. I mean, we're moving away from the threshold point.
I have some degree of sympathy, though it's somewhat attenuated by the fact that we say the procedure was plainly deficient about the judge in a more urgent situation on the 9th. We have a far lesser degree of sympathy, respectfully, by the time he had the opportunity to pause, reflect, and review, as was.
Sorry, I didn't understand who you got sympathy for.
In terms of the judge's position in the issue having arisen on the 9th.
Yeah.
He actually had...
Oh, sympathy for this judge, for Mr. Justice Williams, sorry.
To some degree. In terms of if this issue arose for his consideration. The process of review should have alerted him to the need to step back from the precipice. But I don't approach, albeit my clients do not wish this genie box, whatever it is, to be opened up plainly, but consistently through our case, from the moment we heard the terms of Mr. Justice Williams's decision, we have pursued a consistent thread, which is you're applying the wrong
Of
test.
inconsistency, Mr. Barnes.
It's not a virtue on its own.
I mean, and you might even go so far as to say that the situation for everybody would be better if it had never been raised.
Indeed, and that speaks to why.
Might even be common ground all round in a way.
But it speaks to why the answer to any real risks that might arise are not
is
answered
other
by
than
this remedy.
anonymisation.
And that goes to that balancing exercise towards the margin of appreciation, which we say it means that if the European Court has not established that this protection arises in this context for judges, this country, with the common law tradition meaning that judges play a particularly prominent constitutional role, and where, insofar as there is support, it is only support for the fact that judges are named and should be named in all circumstances, even to the point of requiring close protection officers in Northern Ireland, or sitting in terrorism cases in this jurisdiction, dealing with controversial issues. And if that applies to magistrates in the Felixstowe Justice's case, if it applies to magistrates and legal advisors in the Finney Bowden Marsden case, then it absolutely applies to these judges. And I push back very firmly on the suggestion that the public interest is met by the disclosure, and that's sufficient. I fully endorse the submissions that my learned friend made about the degree to which that is licensing, taking on that editorial function. But if there is a tension between the individual behaviour, the overall systemic pressures, then knowing and being able to debate who a particular judge is, what their role was, how they approached their task, how they've conducted themselves in other published cases, that is absolutely integral to the process of accountability and public oversight. That is not just in the public interest, it's genuinely in the family court's interest to ensure that there is proper scrutiny. And names are important, that is well established, and the names of judges are fundamental. I also placed before the court yesterday the case of NS and Croatia. And I'd ask, in that context of necessity in the democratic society, that starts at 26.
Is it separate, that case?
I think it is. I believe my lady has it separately. I think it was emailed to my Lord the Master Rolls' clerk yesterday morning. And the individual we'd left out of that was my lady, Lady Justice King, who got the authority somewhat later.
Yep, got it. Paragraph.
Well, it starts on page 20, at the bottom of page 26, but it's principally page 27 that I wanted to turn my Lord's attention to. There is the quoted text in relation to freedom of expression. This freedom is subject to exceptions which must, however, be construed strictly, and the need for any restrictions must be established convincingly. The adjective necessary implies the existence of a pressing social need. Contractual states have a certain margin of appreciation in assessing whether such a need exists. There is no need for prior restraint in relation to the anonymity of a judge. And paragraph 94 at the bottom of that page relates to the particularly high level of protection of freedom of expression, where they are remarks concerning a matter of public interest. Importantly, if we are narrowing the horizon to the family jurisdiction, which may include issues related to the functioning of a system for deciding on the custody rights and fate of children, and when a particular expression constitutes criticism directed at state bodies acting in an official capacity, I don't exempt the judiciary from that, given their role in decision-making. Those bodies must accept wider limits of acceptable criticism than private individuals. So, my lords, my lady, when we received the reconfirmation following review that the judge was upholding his decision, was doing so on the basis of an Article 8 and 10 balance, as he has expressed in his June judgment, in what we say is a fundamentally distinct context, we pointed out you don't have the jurisdiction under Article 8.10, and I maintain that that is the position before this court. And I don't ask the court to come to that conclusion as a convenient means of simply avoiding the almost impossibly difficult question of how to restrain this jurisdiction or how practically to manage the consequences if you let the genie out or open the box. If that is where the case law takes you, then we'll see where the chips fall. But I say that the principled answer is that...
6 metaphors in one sentence. Opening the box, genies, chips, marvellous.
There are many analogies, and I'm sure none of them will feature in the court's ultimate judgment for good and coherent reasons. I think, having entirely inverted the manner in which I intended to deal with things, could I finally finish just before lunch on the slightly more prosaic issues that still remain? As with Mr. Verdon on behalf of the children, my clients do not want to lose sight of what was gained through this process. They have been assiduous in pursuing their applications. They were the first to bring them. They have pursued them throughout. They've pursued them as freelance journalists, exercising their journalistic function in the public interest. They have responded to what they considered to be an exceptional and urgent situation when this decision was made and when no judgment was provided. We are grateful genuinely for the manner in which the court has engaged with that. My clients have managed this process without a solicitor in seeking to comply with the very rigorous, justifiably rigorous demands of this court, and I hope that their engagement has facilitated the court dealing with these matters on an appropriate expedited basis, but they deserve commendation for the manner in which they have gone about that task. I am personally grateful for the support they have provided. They are grateful for the fact that, whether through tortoise or, more importantly, and before this court, through Law for Change, they have received genuine support from either a media organisation or a charitable organisation that are committed to standing by the principles that they have relied upon before this court and which they genuinely believe, having engaged for many years with the family court. That is not a straightforward process. They have moved matters forward in a way that has informed the public, and they very much hope that this decision puts the question of judicial anonymity to rest. That is their aspiration. That is why they took the steps to be represented before this court. But they also hope that what underlies this, and where I depart from my Lord the Master of the Rolls, is that Mr. Justice Williams does briefly deal with why he has made the expansive disclosure order he has. But in a sense, it goes to the strength and force of that argument. And if that reflects the continuing evolution and commitment to opening up processes that has even arisen since my lady's decision in relation to Newman, that now in serious cases where there is genuine public interest, there is a recognition that informing the public through the media is of critical importance, then we see that as a valuable trajectory and one that shouldn't be lost sight of in the course of this. This judge did make a decision to provide that disclosure. That disclosure has been made. That disclosure has informed reporting, and no party has sought to challenge it. There were those who sought to resist it in the court below, but they accepted the judge's reasoning and the manner it applied in this case. That is progress, and we hope that this decision is progress too. And I finally say this in relation to the grounds as a whole. I know my Lord Master of the Rolls raised that an appeal can be allowed on a narrow basis, it could be allowed on one limb alone, and I know that the court is clearly and understandably, given the general application focused on the broader principles, the thresholds, and the jurisdiction, we say that on those grounds, those substantive grounds, this appeal should be allowed. But we do say that the procedural component is important. These decisions should not be taken in a manifestly procedurally defective fashion. It makes the process worse, it makes decisions worse, and it isn't a fair process. And so we say, whilst there may be an attraction to the court of trying to limit the focus of its attention, we say the procedural matters, both the failure to give notice and the failure to give reasons, are important. And I would finally say this. My clients have engaged in good times and bad with the family court. The reason we raised the additional ground for which I do invite the court to grant permission, and I do invite the court to allow the appeal on the basis of, is that if there is a genuine commitment to transparency, there should be fidelity to the law that is to be applied. And the Court of Appeal makes clear that in recognition of Article 10 rights, journalists should not come to court to have their professional integrity questioned by a judge, let alone in a process that is unfair and without notice to them, is without a proper evidential foundation, and includes a broader sideswipe at the entire media industry. That is a dramatic misstep in this case, and the importance of this court allowing the appeal on that basis too is that that must not be allowed to take root. That approach must not be allowed to fester. Insofar as Mr. Verdon suggests that that may be inappropriately fettering a judge from making the comments that they wish, we say the case law is clear. They were not comments he was entitled to make, and this court should allow the appeal on that basis too. I hope, at 1 minute to one, that that's all the assistance I can give, but if there's anything else, I'm happy to.
Very helpful, Mr. Barnes, very helpful. Does anybody else feel the burning need at 1 minute to one to make further submissions in this case?
I was going to make some brief submissions. The only one, I see the time, which I'd very briefly like to make, and it will only take a minute or two, is this, that the court asked the question, have things changed with reference to the European authorities? And of course, the court will have in mind Lord Staines's warning in Ries about not introducing new exceptions to the open justice rule except in the where the most compelling circumstances arise. One thing in my submission that has not changed, perhaps has changed only insofar as it has got stronger, is the need for public confidence in the administration of justice and the rule of law. And any step that is taken which is inimical to public confidence in the administration of justice should be resisted in my submission. The need for that at a time of social media chaos is all the greater. And when one looks at the European authorities, it's plain, none of them deal with the question of judge anonymity, but as we saw from what Mr. Justice Mumby said, citing from the DeMace case, and this is 3B, we looked at it yesterday, the European authorities reflect that the need under Article 6 for confidence in the administration of justice to be fed through transparency. And there is nothing in any of the European authorities which the court has seen today that in any way qualifies that important principle. So, in summary, my submission is the only thing which has changed is the need for the courts to reflect with added vigour the need for transparency to give effect to confidence in open justice in the justice system. Just one factual point, finally. It was said by Mr. Larazadi that it was just Mr. Barnes who put in a note to the judge on the subject of anonymity of judges. In fact, my junior, Mr. Rowe, sitting behind me, also put in a note. So I don't want his work to go unacknowledged.
And indeed PA Media, I think,
And PA Media did as well.
Yes. Yes. Good. Thank you. Well, may I conclude by thanking all counsel for the massive amount of hard work that they have put in, together with their solicitors, and also those who are neither counsel nor solicitors but have made submissions to the court, either in writing or orally. We do appreciate the speed at which this case has been got ready. I'm afraid we're not going to deliver an extempore judgment at 2 p.m., which obviously you had thought we would. We will instead take time to consider our judgments with great care, because the arguments are of significance, as I said, in giving permission to appeal at the end of last term. I don't know whether we will hand down a judgment in draft in a case like this. We may not. But if we do hand down a judgment in draft, you will be aware of the stringent confidentiality attaching to that judgment and the need only to use it to agree an order and the disposition as to costs. Either way, we will do our best to get you a draft judgment or a real judgment very quickly, but the difficulty and importance means that personally I would rather take time and have a judgment that is dependable. So it may take more than just a few days. So don't expect it tomorrow.
My lord, I rise only to say this. I know that Miss Reeves, who has been assisting the judges, followed some of the hearing, albeit not present. And I did communicate with her the discussion that my lord and I had about the process of notification of outcome, but deferring publication.
We have taken that on board. We understand.
And I think it would only be right to express that insofar as if the answer is the lifting of the restriction, that notice to allow for proper preparatory steps is something that,
Yes.
that Miss Reeves and the judges would invite.
We're going to have to decide how to do it, and we haven't decided yet. So
Indeed, I only raise that as a matter of fairness, given that they aren't
depends
present
on all
before.
sorts of things, like the decision, for example.
Absolutely.
Good. So, as I say, the argument has been very helpful, and we're grateful to all. And that concludes the proceedings. Many thanks.